Good evening, ladies and gentlemen. My name's David Theroux, and I'm the president of the Independent Institute. I want to welcome you to our Independent Policy Forum this evening. As you know, we as an institute hold events like this on a regular basis. They can be lectures or debates or panel discussions and other formats that we use here in Oakland. Our program this evening is especially timely and momentous, really. Celebrating the latest victory in the support of the Bill of Rights of the U.S. Constitution, especially as more and more people today are increasingly becoming concerned about the growth of federal power and the abuse of civil liberties in the United States. More specifically, the U.S. Supreme Court's 2008 landmark decision in the case of Heller versus District of Columbia, as many of you know, ruled that the Second Amendment protected an individual right to keep and bear arms. And last month, almost a month ago, a second historic decision by the court in McDonald versus Chicago now overturns the ban on handguns in the city of Chicago and elsewhere, and also affirms further the Heller decision. One of the questions is, what was that all about? And the second one is, where do we go from here? Our event tonight is entitled The Supreme Court and the Battle for Second Amendment Rights. And we're quite pleased to have as speakers two really top legal experts, one being Stephen Halbrook and the second being Donald Kilmer. Before we begin, for those of you who are new to the Independent Institute and are here physically, there's information in the packet that hopefully everyone got a copy of. You'll find information about upcoming events, books that we publish, our journal, The Independent Review. This is the current issue, edited by Robert Higgs. You'll also find information about media programs and so forth. And for those of you who are joining with us live on streaming, which we provided for this event. You can find information on our website at independent.org, and we would welcome everyone to become a member and a participant with our program. The Institute itself is a public policy research institute. We sponsor studies of major social and economic issues, and issues of law are certainly one of the top priorities. Also in the packet, I should point out, there is a flyer about our summer seminar program for students. And the second seminar, which we're holding this year, will be held August 9 to 13 here in Oakland. Those of you who have children high school age or college age are welcome, and we would encourage you to participate. It's a one-week program, and it's known as the Challenge of Liberty Summer Seminars. In 2008, and after nearly 70 years of virtual silence on the Second Amendment, the Supreme Court did rule, as I mentioned, that the Second Amendment meant an individual right to self-defense regarding the ban on handguns in the U.S. Capitol. But in deciding that the federal government could not ban the ownership of handguns, the question remained whether the Second Amendment of the Bill of Rights also pertained to state and localities. And this was a contentious issue, and basically the claim of the mayor of Chicago. In a second historic ruling in McDonald that I mentioned, the court decided that the Second Amendment does indeed apply to state and local governments, based on the incorporation of the Bill of Rights by virtue of the Due Process Clause of the 14th Amendment. But why is this the case? And is the court correct in its assessment? Why was the 14th Amendment proposed in the first place? Why was it adopted? And what does this have to do with any of us today? To address these and other themes is why we're holding this event tonight. We're also quite pleased to be the organization that sponsors the publication of a number of Dr. Halbrook's books, two of which we're featuring tonight. The first is the book, The Founder's Second Amendment, Origins of the Right to Bear Arms. And the second is the book, Securing Civil Rights, Freedmen, the 14th Amendment, and the Right to Bear Arms. And I want to point out that in the recent McDonald decision, these books were cited 6 times.